So when the court came to the conclusion that it is not possible to have the president appoint at whim. Officers who should have been elected at Congress. That fight cannot be faulted. That's the only conclusion. My lords and my ladies, the meeting of the 15th February 2018 was addressed in full on page 10 of the record. Paragraph 24, page 10 to 11 of the record, paragraph 20. That purported meeting.
Paragraph
24. That purported meeting, which is admitted now, had an agenda set before, could not have been used to discuss a possible successor.
You're not being very clear, Mr. Mzungura. What are you saying? Are you saying that the meeting of the 15th February 2018, are you saying it was invalid, it was unconstitutional? What are you saying about it?
It was invalid. It was attacked.
Why?
Because it could not have been set to discuss a possible successor. Why? Because the Constitution already provides for a successor. Secondly, the National Council and whoever sat there had no power as provided in the Constitution to do that. So from the onset, bear in mind, my lords and ladies, that the Secretary General was part of the respondents. So is everyone else. That whatever they were doing was in contravention of the provisions of the MDC Constitution. My lords and ladies, Article 18 is qualified as follows. That's page 77 of the lead document. Maybe before I address my lords and ladies, maybe before I address that, let me first conclude this by dealing with Article 9.1.4. So that I finish this one. 9.1.4, my lords, page 56 of the lead document. It provides that the president shall appoint deputies to officers of Congress. Provided, I'm skipping the other words, provided that is provided for in this Constitution. That should have been provided in this Constitution. Then we go on page 15 of this lead document. Page 15 of this lead document. Where it says, the National Standing Committee shall be composed of the following. It includes presidents with an S. These are elected at Congress. But on K, my lords and ladies, it says the Secretary for Elections who shall be appointed by the President. It is clear
Sorry, if I can understand what you're saying, Mr. Mutungura, you're saying that the President can, in terms of 914, appoint other office bearers where this is provided for in the Constitution.
yes,
And this is only provided for in respect of the Secretary for Elections.
that's correct. I submit then, my lords and ladies, that the appointment of the second appellant was contrary to the provisions of the Constitution, and as such, null and void, as was found by the court. The issue of residue judicata, my lords and ladies, has been raised. May I refer the court to the issues that were dealt by Makoni J. As she then was. The court is the copy of that judgment. On the front page of that judgment, my lords and ladies, it clearly spells out the issues that were brought before the court. We compare that, my lords and ladies, to the issues brought before the court. Those are different. The only issue that is similar is number one, the appointment of second appellant. The issue of appointments, reassignments was never argued. The issue of the extraordinary Congress was never brought before Makoni J as she was. Then, to then argue that there is an extent judgment that has not been appealed, which should have closed this matter in the circumstances, is unfortunate. And there is no legal basis. My lords and ladies, I will move to address the issue of domestic remedies, whether or not they were exhausted. This application was brought in terms of section 67, 2D of the Constitution. What the court found to be the basis of allowing the matter to proceed. Number one, it said there was no domestic remedy sufficient enough to cater for this scenario. But in any event, if it was there, it was not sufficient. As is apparent from the record, my lords and lords, for lack of a better word, it is clear a palace coup had happened. The first respondent was in charge. The first appellant, second appellant, Mr. Nelson Chamisa, my lords. The chairperson was also in charge, Mr. Morgan Comich. From the minutes that are attached to the record, my lords, that is page, you would find that the person who introduced the agenda of that day is second appellant. The minutes of the 15th of February 2018, page 118 of the record. It says the acting president explained the purpose of that meeting. Correct, madam. In those circumstances, my lords and ladies, not how could there be any remedy available?
Which particular purpose do you find objectionable?
I beg your pardon, my lord.
You say the second appellant explained the purpose of the meeting. Which particular purpose of the meeting do you find objectionable?
Number one, my lord, he was the acting president, or was affirming.
No. Any of the purposes, the reasons set out in paragraph 10. Any of them problematic as far as you're concerned?
10.2. The way forward. Not only that, the issue of the cohesion in leadership was also addressed in that meeting. Paragraph 13 on 121. Page 121. Paragraph 13.6. It says to establish the 13.6 on page 121. To establish the unstable leadership cockpit. Firstly, the National Council put to rest the acting debate by reaffirmed Advocate Nelson Chamisa is the party's current acting president. The minutes says he was chairing. We haven't seen any evidence contrary to that. And then an organizing secretary, Mr. Mashale, from Goko Sesame district, would and lodge an appeal against that. And his concerns be fully addressed by this well-coordinated my lords and lords, I will request for 10 more minutes. Thank you. It puts to rest the issue whether there were any domestic remedies sufficient enough to address the concern that the first respondent had. My lords and lords, the next issue that I'll address is the issue of the first appellant having been barred. This position, I submit, has been settled at law, and I referred to the judgment on page 3 of our heads, 5.4. Herald Cron and another versus Energy Resources Africa Construction. By heads of arguments, 5.4. 5.4. In which Patio JA agreed to that judgment. That it's not good enough that I'm authorized without proof of such. And the court cited with approval Mazire and others versus Jarivat. We have addressed that fully in our heads of arguments, my lords and lords. And we believe that position is the correct one. More importantly, this is fortified, my lords and lords. I refer the court to page 18 of the lead document, the Constitution. Which deals with the powers of the National Executive Committee. Page 18 of the lead document, powers of the National Executive Committee, and in particular, under paragraph J, paragraph J provides that the National Executive Committee have power to institute legal proceedings for and defend any legal proceedings against the party. It does not say the chairman. And membership to that National Executive Committee is provided for under 6.5.3, page 17. It goes without saying that there was a reason for a resolution from the National Executive Council to appoint Morgan Committee to act on its behalf, because he is not the one who is entitled to law to do so. This does not amount, my lords and ladies, to denying the respondent then to defend itself after we dragged it to court. This is actually different from the position or the case of Mudzenge and others, in the sense that in the Mudzenge matter, the applicants had sued a union and went on to argue that it had no legal capacity to stand for itself. The court could not agree with that. In this matter, the appellant is defined in terms of his conscience as a legal entity capable of suing or to be sued in its own name. That is not in dispute. What is in dispute is, did the Morgan Commission have authority to represent? Because the Constitution does not give him such powers. My lords and ladies, the decision of the court AQUA, I respectfully submit, is an asylum. The appellant's case stands no chance. We pray that this appeal be dismissed in its entirety with cost as prayed for. Unless there is a particular point, my lords and ladies, that you wish me to address on, that should my address.
Let me ask you this question. If we were to agree with you, I'm not saying that we will. If we were to agree with you, what should happen? What order should ensue from this court?
That the appeal is dismissed in its entirety with cost.
There's a reason why I'm asking this question. As I understand it, the last Congress of the first appellate was in September 2014. Am I correct?
We now confirmed it was in October, end of October.
End of October 2014.
2014 to the 1st of November.
Sorry?
To the 1st of, it was actually from 3rd to 1st of November 2014.
Sorry, can I have the dates again?
30 October to 1st of November 2014.
30 October to
1st of November 2014.
And we know that Congress must be convened at least or every 5 years.
That's correct.
Which means the 5-year period expires in about a week from now.
That's correct, my lord.
Now, in the event that we agree with you, would the order made by the court of law still be applicable?
Thank you, my lord. And the Constitution provides for the ordinary Congress to be held within 5 years. 5 years. The Constitution provides that succession be dealt with through an extraordinary Congress. The matter is spilled over to the courts. The primary question that needs to be addressed is compliance as the first respondent have approached the court with the Constitution. Succession of the late Dr. Richard Morgan Changirai is the starting point. I believe the court would not say that is impossible to happen. The court would not say it's still unsustainable.
No, I asked that question because I think everybody's agreed that things should have been done in terms of the Constitution. And the Constitution, the same Constitution says the next Congress is about a week from now. Obviously, the order that we make in the event that we are with you would be affected by these very same provisions of that same Constitution.
My lords, whilst I agree with that point, my lords and ladies, what it means as we speak today is that the structures of the court is...
Or maybe, let me put it this way. Can we, as a court, extend that period in order to ensure that there is compliance with other provisions of the Constitution?
Thank you, my lord and lady. I'm going to answer it in two parts.
Perhaps before you do, you may need to distinguish between the regular 5-year Congress from an extraordinary Congress to appoint a president. That there are two different entities, they're two different creatures, are they not?
That's true. That's correct.
So you need to address both.
Thank you, my lord. That's why I had to answer it in two parts. My lord and lady, in terms of the Constitution, an extraordinary meeting requires 1 month in terms of the Constitution. The ordinary Congress, 2 months notice is required. Now, the extraordinary Congress meeting relates to...
Ordinary Congress requires 2 months.
Ordinary Congress requires 2 months.
Ordinary Congress.
Ordinary Congress requires 2 months notice. Extraordinary requires 1 month. In compliance with that now, of the extraordinary, because the challenge that was upheld by the court is that there was no succession that has happened. So, what has to happen is that the status quo is to deal with that issue first before calling the ordinary Congress, because that will create problems. So this court actually has that power to deal with the issue of an extraordinary Congress having the need for it to be held. It does not necessarily to be a month notice. It can give it.
So what you're asking this court to do in the event that you are successful is this. Firstly, that we order the convening of an extraordinary Congress within a specified period and the convening of a Congress by whoever is appointed president thereafter. Is that what you're asking?
The issue of the Congress, I would leave it for the administration of the party.
Well, it's due to happen at the end of this week. We don't want to, as counsel for the appellant has indicated, we don't want to interfere with the functioning of a purely voluntary organization unnecessarily, unless we have to.
Now, my lords and lords, to answer that now, these are not on record. But the court will take judicial notice of the fact that there is an ordinary Congress that was held purportedly under the name of the first appellant. When was that? In May, soon after the judgment came out, and on the eve of lodging of this appeal, there was some ordinary Congress purportedly held.
Sorry, an annual Congress or the
5-year one.
Annual Congress? Which one?
The 5-year one.
In May?
In May.
That's the ordinary Congress.
That was the ordinary Congress. I might verify on the actual date. There was an ordinary Congress held which ushered the new office bearers, because this is why my learned counsel was saying, Douglas Togara saying was Secretary General. Now there is Charlton Wendy. This is the court can take judicial notice of that. You're
still confusing us, Mr. Mfungura. So you say There was an ordinary Congress.
In answering your question,
There was an
Are you
ordinary
saying
Congress.
that the 5-year period was anticipated in the sense that instead of holding